These are my full takes on the recent Supreme Court case that was just ruled on July 1st, in which Donald Trump is bringing a case before the Supreme Court seeking some forms of immunity from criminal prosecution for at least things that he considered to be official acts of him as the president. A lot of people are talking about this, probably people who either haven't read it or don't understand it or have, some agenda that they're interested in pushing about it. But regardless, here's my reading of it, of which we've spent the last 3 days painfully going over the entire decision. Chief Justice John Roberts, writing their majority opinion, argues that the president has 3 different types of actions that he can take and then creates a novel ruling about the types of criminal immunity that would apply to the president. So the 3 buckets that John Roberts basically groups actions into we have core powers, which are actions that any action that's taken here is given absolute immunity. These actions are not only beyond judicial review, none of these acts are able to be cited or referenced in any other criminal matter as evidence or otherwise. So if Donald Trump is performing some action that we consider to be conclusively and preclusively within his role, so for instance, conversations between him and his officers, like the heads of his departments, these things would be beyond all criminal review. You can't probe into them. You can't cite them for anything else. So for instance, let's say that we knew that Trump said, I'm going to fire you unless you do XYZ criminal act. I can't criminally indict him for that. I can't even use that as evidence towards another crime, which is going to be relevant for obviously for Trump's criminal prosecutions. But the second bucket that he's got, he calls these things official acts. So official acts are actions that the president takes on that are up to the outer perimeter of all of the things that a president can do, as long as it relates to the effective discharge of a president's powers. So any action that's declared to be even in the outer perimeter of what a president might do as an official act are given presumptive immunity in order to protect the president's ability to execute the duties of his office fearlessly and fairly. I think that if you just imagine historically how the United States was founded, the idea of creating an executive who was beyond criminal prosecution is kind of silly. Obviously, none of the framers had this in mind. That would be ridiculous. We just rebelled against a king. Why would we make another one? There cannot be any danger whatsoever for the president to perform his job. So if you're doing an investigation, even if you think he might have done some criminal act, if that investigation risks damaging his ability to perform any other act, if you can't prove that there would be no risk there, that action is also given immunity. One thing that's important too when we think about this type of immunity that's being granted, this immunity is not like a defense that one would use in court, or it's not a defense that you would use on appeal. This is like a thing that comes before any court action has even happened. So we're not even in any part of the court stage. It's not like the president would go to court and would use this as an affirmative defense, like self-defense or something. This would be stuff that would completely prevent all of these things from ever even being showed in any trial or anything. Those are official acts. Then the third bucket are things called unofficial acts. These are actions that the president takes essentially as a private citizen. I mean, he could take these actions as president, but they're just unofficial acts. They have nothing to do with his job as president. And obviously, Roberts says that for unofficial acts, there is no immunity. Now, unfortunately, we are given absolutely no guidance nor examples for what a private act might be or an unofficial act might be. Roberts notes that in dividing official from unofficial conduct, courts may not inquire into the president's motives. Such an inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegation of improper purpose, thereby intruding on the Article 2 interests that immunity seeks to protect. So when you're doing investigations and you're trying to separate an official act from an unofficial act to figure out, was the president operating in his capacity here? For instance, let's say when he gives a speech, he could be acting an official act or unofficial. You cannot consider the president's motivations when you're trying to figure out whether or not this would fit the official or unofficial act. And unofficial acts obviously can still be indictable and can come under judicial review in the criminal justice system. But what all of them are skipping over is the idea that the official acts presumptive immunity could be unfathomably broad, and we've been given absolutely no indication by Roberts, by this court, what those official acts might be.